Good morning.
In unison, good morning, Your Honor.
Let's see. I understand that the district attorney has requested the out-of-presence hearing on the foundation on the books.
Yes, Your Honor.
What exhibit number is that?
Number 841 and 842.
All right. I did review those materials, as I had requested. I did get the materials, and I looked at those books and indicated that there must be further foundation. Are you prepared to go forward with that?
I am, Your Honor. Foundation with regards to where seized, do you mean?
Yes. Connecting.
Yes, we're prepared to do that at this time. We'll call Detective Rosibel Smith to the stand.
When you get to the witness stand, remain standing and face the clerk.
I do. Please be seated. State and spell your name for the record. Rosibel, Rosibel. Ferrufino, Ferrufino. Smith, Smith. Thank you.
Tell us your current occupation.
I'm a police detective for the Los Angeles Police Department, currently assigned to the Threat Management Unit of the Detective Support Division.
How long have you been a police officer for the city of Los Angeles?
For a little over 20 years.
And your current assignment involves what?
Aggravated stalking cases, criminal threats of elected officials, and workplace violence incidents within the city of Los Angeles.
Did you work also as a sex crimes prosecutor, sex crimes detective?
Yes, I did.
For what period of time?
For 9 years.
All right. Which period of 9 years was that?
From 1988 to 1997.
Did you have occasion to conduct and execute search warrants during that time?
Yes, I did.
In August of 1993, did you participate in the execution of a search warrant at Neverland Ranch in Los Olivos, the county of Santa Barbara?
Yes, I did.
And did you seize objects from that residence during that search?
Yes.
May I approach the witness?
Yes.
I'm going to show you 3 objects at this time. Exhibits number 841 and 842. Would you take a look at those 2 objects, please?
Okay.
Do you recognize those 2 books?
Yes, I do.
Did you seize those 2 books?
Yes, I did.
From where?
These books were seized from a cabinet within Michael Jackson's closet in the master bedroom.
All right. Describe his bedroom for us, please.
The bedroom is a very large.
Your Honor, I think it would be cumulative at this time, wouldn't it?
Sustained.
All right. Tell us where in his bedroom this particular closet is.
It was off to the side of the main bedroom. There were 2 closets on either side of the room, and this would have been the side where the jacuzzi was located.
Now, this is the first floor of his bedroom suite, is that right?
That's correct.
Was there a bed in that bedroom suite?
Yes.
I'm going to show you exhibit number 856.
Okay.
Do you recognize that photograph?
Yes, I do.
And that photograph is what?
This is a photograph that was taken during the search warrant of Neverland Ranch, and it depicts the file cabinet that the books were seized from.
All right. And is that file cabinet depicted in that photograph?
Yes, it is.
How many drawers in that file cabinet?
4.
In which drawer were those 2 books seized? From which drawer?
From the 3rd drawer.
Was that file cabinet locked?
Yes, it was.
How were you able to unlock it?
We were able to get the key from. The maid brought the key over to the home and we were able to unlock it at that time.
Do you remember which maid that was?
I believe it was Blanca Francia.
Thank you. Does that photograph accurately depict the subject matter contained within it?
Yes, it does.
Move to introduce 856 into evidence.
For the purposes of?
For the purposes of this hearing.
For this hearing, I have no objection.
Then it's admitted for the purposes of the hearing.
And I have no further questions as to foundation for this witness.
Cross-examine?
May I approach the witness to take a look at the exhibits, please?
Yes.
And I have no questions for the purpose of this hearing.
All right.
I would move to introduce into evidence 841, 842 as well.
Well, and I suppose that's the purpose of the hearing, Your Honor. We had previously objected, and, excuse me 1 second. We still object on the grounds that this is remote in time. We have books from, seized in 1993 with regard to events that allegedly occurred in 2003, so the probative value of these books is minimal at best, and it's outweighed by the confusion to the jury, prejudicial effect, and everything else. There's got to be some connection in time. It's just plain stale to bring in something from that far back and try to use it by way of not much more than innuendo at this time. These books were not shown to anybody. There's no evidence they were shown to anybody. No evidence they were shown to minors. They were locked in a cabinet.
What about the Memro case, People versus Memro, cited by the prosecution? The only relevance I see would be to the 1108 evidence that was introduced, as these books could be viewed as supportive of the other 1108 evidence. That's what I think their purpose of introducing the books is.
Well, I think that is. I mean, I can't imagine what else it would be. That's what I'm saying. In other words, there's no evidence that these books, or any of the other books, the actual books that were seized, many of which, or all of which the court has allowed from the 2003 time period, there's no evidence that they were shown to any of the people in this case. Not shown to minors. They weren't used for any purpose. They're just shown. I'm sorry. They were offered to show that Mr. Jackson had these materials in his house. I think the court's now heard all the testimony. I think it's very minimal weight even for the 2003 materials. And so my concern is that while Memro might talk about allowing this kind of evidence to show that the individual had this evidence in his possession at the time of the offense, this isn't the time of the offense. This is 10 years before. And it's locked in a file cabinet. So not only do you not have it being used for any untoward purpose, but it's simply possessed, and it's possessed in a secure fashion, and it's possessed 10 years before any events in this case. It just seems to me that at some point the court has to draw the line. And the court has, of course, been drawing lines throughout this trial as to what has the kind of probative value that should come before the jury and what doesn't. And I think that, given the fact that the only materials that there's any evidence were shown or seen by minors in this case are adult heterosexual magazines that are lawful to possess by adults, the fact that they have attempted to introduce from a giant library of books any book that might have a page or 2 or 5 or 10 of individuals who are not fully clothed is, I think it's just an effort to prejudice the jury. So.
But the Memro case isn't about showing the material to anybody. It's about having the material and allowing it to be introduced as evidence that the defendant may have some proclivity to the type of sexually explicit material that we're dealing with. So it's not a question. One of the issues in this case presently is about whether he showed children that material. But another reason the material's admissible is that it relates to his state of mind. And that's why they're offering it, according to their proffer.
Right, I understand that. And maybe I'm not being clear. But what I'm saying is, yes, there is no showing that it applies to the other purpose. So therefore, it's evidence to show that it's being offered to show that the person who possessed it has an interest in these materials. And if that's all it is, then my position is that because it's 10 years old, the probative value is very, very weak.
If it's offered to show that he had that interest at the time of the 1108 allegations, that's the probative value. And you say that's?
And I'm saying that's very, very weak.
I just want to be sure we're seeing it the same way, and I think we are. Okay.
Yes, and I apologize for not being more direct in answering the court's questions. But I guess what I'm saying, at some point you have to draw the line there. In other words, this case really isn't about 1993. 1108 only allows that to come in for really a limited purpose.
True.
And now we are embellishing the limited purpose that's already pretty remote. And as the court acknowledged from the beginning, the real question is whether or not this kind of material is going to be so prejudicial when the jury is considering the strength of the case that was presented as to the charged events. And the strength of the case presented as to the charged events is, I submit, much weaker than it was led to. The court was led to believe at the time of the 1108 ruling. In other words, Your Honor had heard some of the evidence, but you hadn't heard all of the evidence. You've heard more evidence and it's gotten worse for the prosecution. Their current case is very weak. This is just an attempt to further bolster that with what is remote. And I understand the court's theory, and the prosecution's theory, let's put it that way, and the court's acknowledgement of that theory. And that's my point. It is remote. It's to bolster 1108. And 1108 is to bolster this case. It's too far afield.
Okay, I understand your argument now.
Yes. Thank you, Your Honor.
Do you wish to respond, Mr. Zonen?
If the court would like, yes. Just briefly, Your Honor, the books that were seized in 1993 were seized at a time that was contemporaneous with the evidence presented pursuant to 1108. There were 4 young boys who were involved in Michael Jackson's life. It's interesting and unique that the maid who was called to open up this file cabinet was, in fact, the mother of one of those victims at that time. Those books, one of the books, both of the books are pictorial essays of adolescent boys. One of them, about 10% of the photographs are completely nude boys. And the other one, 90% of the photographs are completely nude boys. The possession of those books by Mr. Jackson, we believe, is evidence of a prurient interest in adolescent boys, and it's exactly contemporaneous with the state of the evidence as to all of the 1108 witnesses. Therefore, we believe it adequately corroborates within the meaning of People versus Memro. We'd ask that it be admitted.
All right, I want to think about this issue a little further. I'm not ready to make a decision on that.
Your Honor, could I? I know we go back and forth, and I can't really tell who started and if I get a brief rebuttal. But could I be permitted to make one remark?
Yes.
Thank you. When the court looks at the evidence, I'd ask the court to look at the inscription in the inside of the first book, which is, "Boys will be boys." And I don't know.
Do you want to get the book for me and I'll look at it?
Yes. I take it I may approach.
You may. Yes, you may retrieve the exhibits. Bring both of them. You might as well bring both of them. Officer, I think I let you sit there a little longer because I wasn't sure that someone might want to ask you another question. But I don't think that's necessary, so you may step down.
Thank you, sir.
Your Honor, if the debate is going to go beyond the location of where the books are seized.
Cross-examination is over. The argument's not there in that area. Am I missing something?
No. My understanding was the debate was over the location of the books.
No, the debate. I said I wanted further foundation. I wanted to look at the books, and I wanted foundation. There was no debate. That was my request.
That's fine.
Now I have what I want. I still have to make a decision.
That's fine.
Now, what was your reference?
I don't know which number is which, but the one that's entitled, "Boys Will Be Boys."
Yes.
Which I think is 841, but I'm not positive.
It's 841.
Okay, on 841, if you look at that, it appears to be Mr. Jackson's own inscription, and he says, "Look at the true spirit of happiness and joy in these boys' faces. This is the spirit of boyhood, a life I never had and will always dream of. This is the life I want for my children." M.J. The other book, which would be 842, appears to be inscribed by a female fan, and it appears to have been sent to Mr. Jackson by a fan of some sort. That's the interpretation I take from that inscription.
Well, there is an inscription, to Michael. From your fan.
Yes.
Love, XXXOOO. I was going to interpret that, but I won't, Rhonda. I know what I mean when I put XXXOOO.
And I have noted Your Honor has never put that on any of your rulings in this case. Laughter.
I can't top that. All right, then that hearing. At this point, I'm going to take that under submission, and we'll rule on that before the people rest. And if you're about to rest and I haven't ruled it, tell me. Remind me.
Did you mean rest the case or rest today?
Rest the case.
All right, the witnesses are here today. Are they not going to be testifying today? If they are not, I will go ahead and excuse them.
They can't hear you.
I'm sorry.
What witnesses?
The witness who seized the book presumably would be testifying as to where and what she seized in the course of the trial before the jury.
Oh, I see. You need it for that purpose?
Yeah. If we're not going to do that today, I'll go ahead and excuse her and have her come back.
No, We can do that today.
We could put her to the end of the witness list.
We could put her to the end of the morning.
Your Honor, there was one other matter. A motion that was filed by an attorney who represents one of the witnesses to be called today. Did the court want to address that at this time?
Yes. That's the Drew witness?
Yes, Your Honor.
Is that witness present?
The witness is present, out of the courtroom, and counsel is present before you.
Good morning, Your Honor. Kelly Sager on behalf of Ian Drew, a non-party reporter.
Good morning.
We had filed a short memorandum with the court concerning Mr. Drew's testimony, largely to give the court some guidance and background, which I understand has already come up once in this case, as to the scope of the reporter's privilege under the California Constitution and the First Amendment and the common law. Mr. Drew is being called by the prosecution, as I understand it from Mr. Zonen, to repeat information that has been published by him in a television broadcast. And I assume that Mr. Zonen still intends to limit his questioning to the published material. It nonetheless raises an issue as to cross-examination. And in the Foss case, which we cited in our papers, if it appears that the defendant's cross-examination would intrude into privileged areas, then it's advised that the court address that at the outset, because it may be that if the defendant is not going to be permitted to cross-examine into those areas, that the original testimony should not be permitted either. In either case, I just wanted to make sure the court was apprised that the witness does intend to assert his rights as to unpublished information or confidential source information and to ask the court's permission to be making objections on his behalf.
Well, you have my permission to do that.
Thank you.
You know, I thought your points and authorities were well done and complete. One of the things that you mentioned in your points and authorities was that there's a preference to have a hearing outside the presence of the jury before the testimony is proffered to the jury so the court can determine whether or not the evidence should be allowed.
That's correct, Your Honor.
Based on the right of the defense to cross-examine. Mr. Mesereau, you wish to say?
Yes, please, Your Honor. Your Honor, as the court knows, the witness's name came up during the testimony of.
Just a moment. Would someone create a seat there so she doesn't have to stand?
Thank you, Your Honor.
This witness's name came up during the testimony yesterday of Debbie Rowe.
Right.
And she did testify, among other things, that he had actually interviewed her at Schaffel's house during the subject interview that was talked about yesterday. This witness was secretly recorded on a number of occasions by Debbie Rowe at the behest of the sheriffs, and he also gave a police interview where he talked extensively about various aspects of the case, including Mr. Schaffel and others. Clearly, he had a career motive in doing this. Clearly, there were financial considerations involved, considerations involving advancing his career, and clearly he wanted to be involved in this case. If you look at the secretly recorded conversations, you can gather a lot of his motives to do what he's doing. And to permit him to testify as a prosecution witness and not allow the defense to go into those types of incentives to do various things, say various things, appear in various places, would be highly prejudicial to the defense. So allowing him to just hide behind a journalistic privilege every time his motives and veracity are impeached or contradicted or questioned would be prejudicial to us. He put himself right in the middle of this investigation intentionally, willingly, and knowingly. Met with Mr. Klapakis for an interview. Talked about his knowledge of various individuals and various occurrences in the case as he understood them. Was recorded on a number of occasions by the sheriffs because they thought he had information of significance, conducted the interview. How can they possibly, if he gets caught in a problem, say journalistic privilege? I think that would be highly inappropriate and very prejudicial to the defense. Thank you, Your Honor.
Your Honor, if I could just briefly respond to Mr. Mesereau's comments. Under Penal Code Section 632, I believe any recordings of Mr. Drew that were done without his knowledge would not be admissible for any purpose. As a reporter, he's engaged in conversations with a great number of people, including Miss Rowe, as she testified to, in the course and scope of his duties as a reporter. The fact that those conversations may have been secretly recorded without his permission, without his knowledge, cannot waive any privilege that he has as a journalist as to information he's attempting to gather. He's reported on Mr. Jackson. He did an interview with Miss Rowe, which everyone has a tape of. And as I understand it, the issue about that interview has already been discussed. There have been other witnesses who have testified, and the tape of the entire interview is available. So there's nothing Mr. Drew can add to that equation. As to what Mr. Mesereau described as an interview with detectives, when detectives showed up, as I understand it, at Mr. Drew's office to subpoena him, he was asked about statements that he had made on television, and again referred to those statements that he had already made on television, the published statements. He didn't have an attorney. He didn't have anyone advising him of his rights at that point, and again, I don't think that could be viewed as a knowing waiver of his rights. Nor is that a publication within the meaning of Article 1, Section 2, b, of the California Constitution. He was not disseminating information to the public in any conversation he had with the detective who was serving him with a subpoena. As I understand it, there's one statement that the prosecution intends to ask Mr. Drew about, and that was in this particular television broadcast concerning a conversation that he had with one of Mr. Jackson's, I don't know how you would describe him, someone that Mr. Jackson knew. That person is certainly a witness who could testify as to that. As I understand, it's about whether the family at issue left the ranch at some point in the middle of the night. I don't believe that's disputed. So it's difficult for me to see what Mr. Drew can add to these proceedings in any case, and certainly nothing that would justify invading his privilege by opening him up to questions about conversations he had during the course and scope of his news-gathering activities.
Mr. Zonen?
Your Honor, we intend to limit our inquiry to information that was disclosed by Mr. Drew on national television. It's published information, therefore it's not protected by the Shield Law.
Well, but that's not the issue, is it? I mean,
That's one issue. The next issue is the question of whether or not cross-examination
right.
is important for impeachment. We believe that the information that we are going to be asking him is about a statement made by another person, one of the unindicted co-conspirators, to the effect that the Arvizo family had fled from Neverland, and therefore Mr. Drew would not be able to conduct an interview that he expected to do. I don't know that the content of that information requires an extensive cross-examination into collateral areas. I think it can be adequately cross-examined as to that statement alone without going too far beyond the published information.
Well, I think what we'll do is you can call your witness, you can ask him the questions, and then I'll understand what you're going to ask him in front of the jury and what his answers are going to be.
Okay.
And then we'll see what
Shall we do that at this time?
Mr. Mesereau wants to do. Yesterday he filed a motion to prevent someone from testifying and later withdrew it, so
He might wish to do that today.
I don't know. Call your witness.
Did you wish to do that outside the presence of the jury at this time?
Absolutely. That's the point.
Yes. We're prepared to do that. Would you call Mr. Drew down, please?
As I believe the district attorney knows, Mr. Drew is not in the courthouse. He was told to be here at 10 o'clock.
Oh, okay.
I was asked by Mr. Zonen's office last night to show up early in case the court wanted to hear argument on that.
That's not a problem. We can do the hearing later.
Okay, I will go outside, though, and call him, Your Honor, and tell him to come directly to the courthouse, and he'll be available whenever the court can then hear him.
If he's going to be here at 10 o'clock, that's fine.
I don't know that our other witness will necessarily go to 10 o'clock. If we're not going to be dealing with.
I thought you were going to try to get other witnesses for me.
We are not able to do that. The witnesses we had, I think, were the ones that we identified yesterday.
But I was told you would attempt to get other witnesses to fill the day. Because I didn't give you permission for a short day today, or no day.
I apologize to the court. We are not able to do that.
Go ahead and call your client, please.
I'll do that. Thank you, Your Honor.
We have a witness who's ready to proceed at this time.
All right, you can bring in the jury. Good morning again.
In unison, good morning.
It's getting to be a habit, isn't it? Counsel, call your next witness.
We'll call Detective Craig Bonner to the stand.
I believe you were already sworn. You may be seated.
Detective, good morning.
Good morning.
You've already testified previously, I believe, on a couple of occasions already. Detective, you've already testified previously on a couple occasions. There's an exhibit that's in front of you. Could you take that exhibit, please? And is that exhibit 827?
Yes, it is.
And does that correspond to the sheriff's number 817?
Yes, it does.
Do you recognize that exhibit?
Yes, I do.
What is that exhibit?
It is an audio cassette tape which contains a recording of Janet Arvizo and Frank Tyson, Arcasio.
This is a telephone conversation, is that correct?
It appears to be, yes.
Was that tape recording delivered to a lab in Los Angeles County?
Yes, it was.
And what lab was that?
The Aerospace Corporation and/or the National Law Enforcement and Corrections Technology Center.
The purpose for delivering that tape to that lab was what?
To have them analyze it, and to determine if there were any breaks or stops that occurred within that recording.
Who is it who delivered that tape to the lab?
I did.
Thank you. No further questions.
Good morning.
Good morning.
The National Law Enforcement Technology and whatever it was.
Corrections and Technology.
Corrections and Technology. This is actually a private company, is that right?
It is.
And they market their services to law enforcement, is that correct?
I believe they have a grant through the government that they get paid to assist law enforcement.
Okay, it's a private company, but they market their services to law enforcement?
Objection. Asked and answered.
Asked, but not answered.
Overruled.
Thank you.
I don't believe they market their services, no.
They let you know that they exist and they're available to do work, is that correct?
That's correct, yes.
They get paid by doing the work?
Not by us, no.
They get paid by this grant?
I believe so, correct.
That's your understanding? Alright, now, did you seize this particular item that you took down?
No, I did not.
So you took it out of the evidence locker?
Correct.
At the sheriff's department?
Correct.
And you delivered it down to the lab, is that right?
Yes.
And then you stayed for a while some work was done, is that correct?
That is correct.
Not all the work was done while you were there?
No.
You left it?
Left the item?
Yes.
No.
What did you do?
I remained with this item until they had brought it into their system, and then I retained this item and brought it back to the sheriff's department.
Alright, so they made a copy to do the rest of their work?
They brought it in digitally. I'm not real savvy on it, but basically they played it into their system, which brought it into a computer, and then they utilized that material that was saved onto the computer.
Okay, in other words, that is an audio tape. That's a regular cassette, little reel-to-reel cassette?
Correct.
Magnetic tape, correct?
Correct.
And while you were there, they did some analysis of the actual tape?
Correct.
And then while you were there, they copied it into digital format of some sort?
Correct.
And then you took the actual tape and you brought it back?
Yes.
Alright, now, what is your understanding as to the source of the original tape?
This tape came from the office of Brad Miller.
Okay, in other words, as one of the detectives working on the case, you are familiar with the source of various items of evidence, is that right?
Yes.
And that was something that was seized during the search warrant execution at Brad Miller's office, correct?
That is correct.
In other words, it was not offered to law enforcement as a piece of evidence that was helpful to Mr. Miller or helpful to Mr. Jackson, or helpful to anybody. Is that correct?
I'm going to object as beyond the scope of the direct examination and beyond the scope of his personal knowledge and relevance.
Sustained.
Okay, it was something that was simply seized during a surprise search, right?
Objection. Irrelevant. Beyond the scope of his knowledge.
Well, that's the question.
Sustained. Argumentative.
Alright, it's still my last question. No further questions.
No further questions. I will call Dr. Harry Koons to the stand.
You may step down. Remain standing. Raise your right hand, and face the clerk here.
I do.
Please be seated. State and spell your name for the record.
My name is Harry Koons, Koons.
Thank you.
May I proceed?
Yes.
Dr. Koons, good morning.
Good morning.
What is your current occupation?
I'm a scientist.
You're a scientist in what capacity?
I'm a scientist at the Aerospace Corporation in El Segundo, California. It's the Space Science Applications Laboratory. And our company is it hosts an FFRDC, which is a federally funded research and development center, which primarily assists the Air Force and national security agencies in their space programs.
All right. Do you also have a second company titled the National Law Enforcement and Corrections Technology Center?
Yes. That's also hosted by the Aerospace Corporation and it's funded by the National Institute of Justice.
Let's start with the first one, the Aerospace Corporation. What is your position there with the Aerospace Corporation?
I'm a distinguished scientist.
What kind of work do you do with the Aerospace Corporation?
On the Air Force side, I have flown instruments on spacecraft to make measurements in the magnetosphere of what we call plasma waves, and I'm also an expert on the space hazards to spacecraft.
All right. I think the other microphone is on as well.
Shall I just talk in the middle?
You need to be close to one or the other, but whichever is more comfortable.
Either one is okay.
All right. What is your education, your qualifications, please?
I have a Bachelor's of Science in Physics from the Massachusetts Institute of Technology, and a PhD in Geophysics also from the Massachusetts Institute of Technology.
How long have you worked with the Aerospace Corporation?
I joined them right out of graduate school in 1968.
Give us a sense of what type of work you do for Aerospace Corporation. How do you spend your day?
I have a million hats. I spend most of my time either working on scientific papers. I spend 20% of my time on the forensics audio. I spend about 40% of my time working with the program offices on trying to help them with their problems on their space programs. There's almost no way I spend a given day.
Now let's turn to the National Law Enforcement and Corrections Technology Center. Tell us what that is and how that happens to be associated with the Aerospace Corporation.
It began in 1995. There was an initiative by the National Institute of Justice to find a way of helping local law enforcement agencies in their work. They recognized that a lot of agencies didn't have a lot of funding for detailed forensics work, and so they issued a proposal for organizations with more capabilities to help them. And so Aerospace responded with a proposal, and out of that was formed the National Law Enforcement and Corrections Technology Center at Aerospace.
And what kind of work do you do with the National Law Enforcement and Corrections Technology Center?
I personally am responsible for the audio forensics work.
Are there other forms of forensic work that are done by that center as well?
Yes. Video forensics and also crime scene analysis. We have a large capability in our support for the Air Force, electron microscopes and very sensitive equipment that can be used to analyze materials. And so it's essentially a matrix organization that if the law enforcement center needs something in the laboratories, they go to the person in the laboratories. The video and the audio efforts have been more or less continuous since its inception.
All right. What is it that you do with regard to audio tapes?
Primarily what we do is we enhance the audio to allow for a transcription. Most people would call this clarifying the audio. We also, from time to time, are asked to look at the tapes for special reasons. Some of them, for example, are to identify the number of gunshot wounds, or not, wounds. Gunshots that were fired at a scene that was recorded. At other times to try to identify the number of people that were present during the recording. We've been asked to try to determine where a recording was made based upon background sounds that were heard on the tape.
All right. Are you able to make determinations as to whether a tape is a first-generation or second-generation tape? Is that something that can be done?
We can do that, in some cases, by looking at the content of the tape, yes.
Are you able to determine whether there are breaks in a tape?
Yes. Normally we can determine if there are breaks in the audio in the tape.
Are you able to determine, on occasion, whether a tape is a compilation of prior other multiple tapes?
Normally we can do that, yes.
How do you do those things?
Each one is done in a different way. Let's start at the back and work forward. If you have a compilation of a multiple of tapes, you'll have different background audio on the different segments. And, for instance, if one segment, at the extreme, if it was made in a restaurant, and another section was made out on a street with passing cars, and another section was made in a home with a television on, that you can look at the backgrounds of each of these tapes and identify the background in the ways that you see, and you can see where these different sections are on the tape. You ask, what was the second one?
The second one was breaks in a tape.
Breaks. Okay. For breaks in a tape, you again look at the background, and when you have a discontinuity, or a break in the tape, you'll normally have, the tape will start and stop, start up again, start up again, and you can see signatures of this on the waveforms on the tape. You will also find lines in the background. By line, I mean a constant frequency. For instance, one line which appears on many tapes is a power line at 60 Hz, and if that power line is discontinuous, you could say that the tape was started and stopped when the power line disappears and reappears.
I think the first question that was asked to you was multiple generations of tapes.
Yeah, multiple generation is more difficult. Normally, with the capabilities we have, when a tape is started and played, and started again, there's an erase head on the tape recorder, and the erase head erases the material that was on the tape prior to that. Now, some laboratories have the capability of going in and examining the material of the tape itself, and they may be able to identify if the tape was started and stopped. We can only look at the content of the tape. And normally what we would do when we're asked a question like that is we would look at the beginning of the tape and we would look at the end of the tape and see if there's material which is not contiguous with the material in the middle of the tape, and also look at the end of the tape to see whether, if the present material that was recorded, let's say, is recorded on only one half of the tape. And then if the tape was previously used, there would still be material on the second half of the tape, unless somebody erased it all the way to the end.
Doctor, when did you begin doing forensic analysis of audio tapes?
1995.
How many do you think you have done since that time?
About 200 cases, give or take 10 or 20.
Have you ever had occasion to testify in court as to your analysis of those tapes?
No, I haven't. I've been subpoenaed twice before and I have not testified in court.
This is your first occasion?
Yes.
I hope you're comfortable this morning.
I'm fine.
Doctor, did you have an occasion to analyze a tape that was presented to you by Detective Craig Bonner from the Santa Barbara County Sheriff's Office?
Yes, sir.
Could you tell us approximately when that was?
They brought the tape to us on June 1st of last year. And according to our logbook, which I may want to refer to later, but according to our logbook, they stayed with us while we digitized the tape. Digitizing means taking a copy of the audio from the tape and putting it onto a computer. That was done by a technician and I was standing there while he did that. And then we gave the tape back to Craig Bonner. We went up to my office and we looked at it for a period of time. I don't remember how long it was. There was another gentleman with him, I believe, and then they left. And about a month later, I went through and did a detailed analysis of the tape and wrote a letter, which I sent to him at the time.
Alright, the work that you do is off the digital copy of that tape, then, is that correct?
That's correct.
And the process of making a digital copy of a tape, does that in any way transform the original tape?
No.
It wouldn't affect the integrity of the content of that tape?
No, there would be no effect on the tape at all.
What was your assignment in this case as to the digital copy of that tape? What was your assignment?
Our assignment was to determine if there were any breaks in the audio.
Just for purposes of clarity to make sure that we're on the same topic, did you have an opportunity to actually listen to the tape as well?
Yes, partly. We were listening to the tape, but partly we were looking at pictures of the image of the audio on the screen. I have listened to about 90% of the tape.
Is this a tape of what appears to be a telephone conversation between two people, predominantly two people?
Okay, 2 people.
An adult woman and an adult man and a child?
And a child, yes. 3 people.
Predominantly the adult woman and the adult child, the adult man?
That's right.
Alright, doctor, what did you do with this tape? The copy, that is. What were you seeking to do and what did you do?
Well, the primary thing we were asked to do was to determine if there were any breaks in the audio. And the first thing that I did was I put an image of the audio on the screen and just looked at the entire tape at one time. And my impression was that it was relatively continuous. And, because the background appeared to be about the same level from the beginning of the tape to the end. There's 22 minutes of audio on the tape. It's a 30-minute tape. And then I went in and I started at the beginning and I looked at the segments which were 1 minute long. And the first thing I noticed was that, I think it was 13 seconds or so into the tape, there appeared to be a discontinuity. And so I blew that up and I took a look at it, and there was, in fact, a gap at that time period. And so having seen one, then I sort of had some idea what I should look for if there were others like that one. And so I moved along through the tape, and I identified a number of these gaps. The gaps are very short on the tape. They're about 2 seconds each.
Alright, tell us what you were able to determine with regards to gaps in the tape.
We found 34 gaps. And they had a characteristic signature. And the signature was very close to the same as when the tape was first started. And by this I mean that if you start an audio tape, there are wheels that take up reel on the feed reel that have to turn, and it takes a little while to get those to turn, a little while being a second or so. And during that time period when the amplifier is trying to put a voltage onto that tape, it makes a little signature that looks a little bit like this, and it's a couple tenths of a second long. And if you look at the beginning of the tape, you get that signature very clearly the first time it's turned on. There was no audio in front of it and you see that signature. And what I found, then, was a very similar circumstance, not identical each time. But each time there was a gap, there was a signature that looked just like that one at the beginning.
What would cause a gap in a tape?
Can I refer to my notes on this?
Yes. Please, go ahead.
At the time I was analyzing it, I made a note of what I thought might be causing these. And instead of trying to remember it, I'd like to see if I can find it in here and.
Go ahead and take a look and read it, but don't read it out loud.
Yeah, okay. It was July 2nd, and I made a note.
I'm going to object. There's no question pending.
Sustained.
What I'd like you to do is go ahead and read the notes that you have made quietly to yourself.
To myself.
And then after he does that, I would like to see what notes he's referring to.
I have no objection.
Okay.
May I approach, Your Honor? Hang on, 1 second. Your Honor, could we approach for a moment, please?
Yes. Discussion held off the record at sidebar. I'm going to take a brief recess to give counsel an opportunity to look at the notes before further examination, so I'll see you in a few minutes.